Hello, everybody. We're going to be getting started right now. Welcome to the 2024 Michigan State University International Law Review Symposium. I'm very happy that we all came here. Happy that you guys got all the breakfast. Please have some more. And thank you for coming. So many of you heard me speak last night, so I'll try to not be redundant. James Madison in Federalist 10 told the world in 1787 that a faction is any number of citizens, whether amounting to a majority or a minority of the whole, who are united and actuated by some common impulse of passion, adverse to the rights of others, or to the permanent and aggregate interests of the community. In other words, a group of people who try to deny the rights and decency of any peoples within a community. Now, many a scholar and many a law student have interpreted those words in handling the issues of the subsequent 237 years of political reality. And in those 237 years, wars and empires have risen and fallen, yet the faction remained, changing masks and memberships with the times. And with every dangerous faction that has come along and waged armed conflict against any peoples has come a response. We're all here today to discuss and better understand those responses to armed conflicts and the authoritarians in charge of those factions. Now, the reason that I chose this theme was because in 2022, as many of you heard yesterday, as a 1L law student on this exact floor, actually, right in the SBA office, I saw the tanks roll into Kyiv, Ukraine on CNN, and then I went straight to Professor Favor's property class, wondering, how could a World War II style war occur when both sides can literally FaceTime each other between the bunkers? 2 years later, I bring us all here together to discuss the tyrants of the 2020s. Because we look back on the roaring 20s, the 1920s with flapper girls, prohibition and jazz, and 100 years from now, in 2120 to be exact, people will look back on the COVID kids, on AI, on the Elon Musks and Putins of the world, and say with 2020 hindsight that we all were too blind to see these clear solutions staring us in the face to our modern problems. Now, back in June, I chose this topic because as someone who decided to go to the pandemic before law school, I believe that the future promises of democracy and the rule of law don't just happen, they require toil, effort, sweat equity, and vision to happen. And I have a feeling that many in this room also share that idea, however naive or not that might be. And for anyone who doesn't know by my incredibly hard to spell last name, I'm Ukrainian American, and that's why I joined this International Law Review. I consider it a blessing that MSU College of Law has this institution, because countless peers in this institution have found an academic home, a voice, and a refuge in this international law review. Because like me, in our American melting pot, find themselves between two cultures and two worlds. And as law students, we aim to serve both our past heritage and our future communities. The MSU International Law Review offers a fora for students and academics to engage intellectually in international and comparative law globally. It challenges us as people, as humans, as friends, to seek out what is just across cultures, across religions, and across languages. In my experience as an international law review editor, my perspective on the world has been humanized by discovering our similarities across cultures, across factions, between American and Chinese and Taiwanese real property law, between Central European and Latin American integrations of criminal justice for climate change criminals, between responses among Central American governments to gang violence, and between multinational approaches to the humanitarian rights of refugee girls and women, whatever continent they may consider home. The MSU International Law Review shines a light on the complexities of our world in the rawest sense. Thanks to our fearless, brilliant, and engaging authors. Sunlight is the best disinfectant. The authors you will hear today are masters in their field. Many of them have lived more lives, met more historical figures than we can possibly fathom. It's a miracle we could bring them together in one volume, and you should all feel lucky that you were able to enjoy their time and effort. These authors will embark on legal research and authorship to bring theories and arguments that you hear today onto the page, onto Lexis, and into our world. I'd like to give them all a round of applause for keeping their promise and our journal alive by participating in volume 33. Before I blather on, I would like to acknowledge my symposium committee, Alyssa Lawton, James Wubin, Danielle Hove, Edward Mazzella, Kennedy Clothier, Nick Evers, Caitlin Urisco, Abby Kakovic, Maddie Ackerman, and Marissa Navarro. Without you, this symposium simply would not have happened, and I owe you all a very stiff drink. And with that, I'd like to welcome our first author, Professor Brad Roth. Brad R. Roth is Professor of Political Science and Law at Wayne State University in Detroit. He is the author of Governmental Illegitimacy in International Law, Sovereign Equality and Moral Disagreement, and a wide range of book chapters, journal articles, and commentaries dealing with questions of sovereignty, constitutionalism, human rights, and democracy. Professor Roth served from 2010 to 2018 as one of 3 American branch representatives to the International Law Association's Committee on Recognition, Non-Recognition of States and Governments. And he currently serves on the ILA Committee on Military Intervention on Request. Everyone, please help me welcome Professor Roth.
Thank you, Andrew, and thanks to all. I'm going to have an interesting challenge here speaking to you out of the dark here because I'm all for low tech, as you can see, and I produced this handout for you rather than to try to do projections here so that you can actually carry out with you the precise language of things that I think are worth bringing to your attention. I do feel as though I've lived different lives. And so some of that I'm actually going to be trying to convey to you here by talking with you about 3 eras, which are the Cold War era, the post-Cold War. Oh, thank you. The Cold War era, the post-Cold War era, and what might be called the post-Cold War era, which I would say began roughly in 2014, around the time of the matters that we heard about so eloquently last night. And so I've been tasked with trying to say something of significance about the idea of authoritarianism. And I come to this having participated in a whole series of debates over a long period of years about the question of democracy as an international legal norm. And indeed have co-edited a couple of books on that topic. and much of my own writing has addressed the kinds of claims that got made at the turn of the 1990s about the notion of a democratic entitlement in the international order, or what became known basically by the title of a famous article written by one of the grand old men of international law at the time in the early 1990s, Thomas Frank, The Emerging Right to Democratic Governance. And one might ask, well, how's that going? The emergence never quite emerged, and now we seem to be in a very different space. And so trying to come to grips with what has happened over time and the sort of resurgence of authoritarianism is something that is highly significant from the standpoint of understanding the international legal order and the relationship between the international legal order and domestic legal orders, which is really the focus of all of my work one way or the other. I apply political theory to problems in international and comparative public law, which by the way is intended both as a straightforward description of what I do and as an inside joke. Because there's actually no call for someone who does precisely that combination of things. It seems in political science, though, that refers to 4 different fields. And I'm also too much law for political science and too much political science for law. I think that does actually serve me well in seeking to address this cluster of issues that are really at the intersection of international and domestic legal authority, at the intersection of political and legal theory, and between law and politics. Trying to come to grips with this idea of authoritarianism, which I view in different terms from the way in which it is frequently described, because what I want to argue is that the most important thing to understand about authoritarianism is its status as a structural phenomenon rather than as something that is a product of culture or ideology or individual psychology. There's a lot that is said about authoritarianism as though it had to do with the idea that people are coming from very different cultural backgrounds, some of which are seen as somehow inherently hostile to liberal democratic processes and values. Claims that are made that authoritarianism represents a particular kind of ideology, or that authoritarianism is a product of what Karen Stenner refers to as a disposition toward oneness and sameness, where people are kind of driven by certain psychological tendencies to embrace a particular brand of politics. I don't want to particularly disparage any or all of those interpretations. There is something to be said for the contribution of those aspects to the phenomenon of authoritarianism. But what I want to argue is that authoritarianism is not fundamentally about that, that it is fundamentally a structural phenomenon, and that is something that it is basically a kind of forgotten knowledge in a sense, or knowledge that was forgotten during the heady days of the post-Cold War era, when people imagined that one could generalize a certain set of democratic values. So sort of spoiler alert contained in my document here that you have toward the end of the document. On the flip side, there's the sort of punchline, which is perhaps the most significant statement that comes in my book, Sovereign Equality and Moral Disagreement from 2011, which is this bolded language that under sufficiently adverse conditions, such as extreme ethno-national or socioeconomic polarization, the inability to agree on a fair basic structure of public order, combined with the inability to agree on what measures are inadmissible in the struggle to install or maintain a basic structure of public order that comports with one's conception of fairness, leads informed persons of good faith and sound reason to support ruthless measures against one another. And that is what I want to argue is really at the core of the phenomenon of authoritarianism, that it is a matter of recourse to authoritarian means in the service of whatever ends people might actually have normatively, where those ends seem to be faced with existential threat. And so what I want to argue is that, in fact, the optimism of the 1990s was misplaced from the start, was based on a great deal of forgetting about how we got to where we've been. And I always argued in the 1990s and beyond that the future was going to look more like the past. What I missed was which past it might look like. And so I was a child of the Cold War era, grew up as an anti-Cold War activist. Even my youngest days were growing up in the 1970s and being in college and law school and beyond in the 1980s. And so my way of thinking about the world was structured in accordance with assumptions from that period. But there was, of course, a deeper past, one that was certainly in the memories of people along the way, but that people thought had been relegated to the ash heap of history. And that, of course, is the period of the 1930s. And so in many respects, we are now revisiting kinds of ideas that we thought were very much in the rearview mirror. Still in all, I think that understanding what the fundamental problems were with the optimism of the 1990s can tell us something about the circumstances that we find ourselves in. And so I want to talk a little bit about the basic premises of the global order following World War II. And how it was that certain questions about the legitimacy of states and governments were provisionally resolved at the international level. This is the sort of solution against which the emerging right to democratic governance was reacting. And so you had a divided world. After World War II, there was a certain moment of good feeling in 1945 where people imagined a very elaborate system of international cooperation that broke down within a couple of years. And the world became divided, not just between geostrategic blocs, but between ideological systems. And what was remarkable about this, on the one hand, was that you have basically what might be called Enlightenment-based political theories that were clashing with one another during this period. You had a set of views subscribed to most prominently by states in the industrialized West that could be identified with liberal democracy. You had a counter group of states that associated themselves with revolutionary socialism. And they were joined by the global South in the process of decolonization, so that effectively you had within the United Nations order what were referred to as three worlds: the first world, the second world, and the third world. People forget the origins of the idea of the third world. The third world idea has to do with the establishment of a non-aligned bloc of states representing the interests of the global South primarily, that originates from the Bandung Conference of 1955, and really, with respect to questions about legitimacy of authority, had views that were collectively closer to that of the second world than to that of the first world. And so the international system was an accommodation among these political forces, prioritizing peace and the establishment of a framework of accommodation among people who could not be expected to agree about basic principles of justice or legitimacy of authority within states. And so it's very easy to focus on what these different parts of the international community and their advocacy in the United Nations and other such institutions differed among one another about. It is easy to overlook what it is that they actually had in common, which was a repudiation of Axis-era fascism. That the UN Charter order was based on certain premises that seem sort of anodyne if one doesn't appreciate their context, but that actually represented something very significant and perhaps much more exceptional than one might have imagined. And this occurs to me, by the way, all the time when I teach students, because my students get younger and younger, right, as I get older. People can't remember that all of the historical events that seem to me to be just sort of second nature to invoke. But it is not an accident, I think, that we are 3 generations past the end of World War II, and that there are fewer and fewer people around who can remember what Axis-era fascism really was. And so suddenly you start to get people making allusions to that era in ways that are sort of vaguely nostalgic and perhaps open to the idea that, well, maybe these people had a point. And that's something that, you know, in my experience was really pretty unthinkable. It's actually one of the embodiments of this is a political campaign in 2016, which used the language of America first. What's that about? Well, America First harkens back to 1940, of course. America First was the idea that Axis-era fascism was really just another thing, not particularly our business, and that we should best stay out of it, look to our own interests, and that there was no kind of global project to be defended in all of that. And really quite striking. There have been any number of things, of course, in the last few years that have been striking, but that one, particularly coming from a Jewish background, it makes me quite kind of shocked that people would be speaking in these terms. But the premises of the global order post World War II involved the idea, first of all, that states were understood not as institutions as such. We often think about states as institutions, but rather that states are territorially bounded political communities. That what a state really is from the standpoint of international law, just as you learn in property law about property being a package of rights, in international law, states are effectively a package of rights, obligations, powers, and immunities. And that package is attributed to a political community in the international order, and that political community is established on the basis of territory and the permanent populations of those territories. And then those states are represented in the international order by a set of institutions, what we call governments. And governments assert rights, incur obligations, confer immunities, exercise powers on behalf of the underlying source of international legal personality of the state. And so the idea in the international order, and it wasn't originated really in 1945, but it's very much encapsulated in the UN Charter and in all of the documents that follow from it, is the idea that the territorial political community is the actual source of rights and obligations in the international system. That the territorial political community is a manifestation of the state as territorial political community is a manifestation of the self-determination of the permanent territorial population without distinction. So if you look at the language of the UN Charter, not only the preamble that talks about we the peoples of the United Nations, but you look particularly at the interaction of the specific clauses of Articles 1 and 2 of the UN Charter. Article 2.1 of the UN Charter is about the sovereign equality of states, but that has to be understood against the background of Article 1, Paragraph 2 of the UN Charter, which predicates relations among states on the equal rights and self-determination of peoples. And none of that is defined, of course, in the UN Charter, and it's all very open textured. But the idea here is that peoples are the permanent population of the territory of states. And that idea gets developed much further over time, particularly in the area of decolonization, when many of the clauses of the charter that were really sort of given very skewed interpretation in order to accommodate colonialism, end up being reinterpreted, particularly after 1960, after a wave of decolonization gave rise to a part of the international political community that had significant clout. And so you get, for example, articulations by 1970 in what's called the Friendly Relations Declaration, unfortunate term for it. It's the interpretation of Article 1, Paragraph 2, and its relationship to the rest of the fundamental principles and purposes of the United Nations. And it talks about the sovereign inviolability, essentially, of states complying with the principle of self-determination of peoples, and therefore possessed of a government that represents the whole people belonging to the territory without distinction. So the state is a manifestation of the self-determination of the permanent population of the territory. One of the hidden aspects of all of that is that the idea of nation doesn't really exist in contemporary international law. Where you see the word nation, it is parasitic on some other idea. And so what someone is a national of a state, that has to do essentially with being associated with the permanent population of a particular territory to which statehood is ascribed. The idea of nationhood that is somehow non-coextensive with the boundaries of states is something that is essentially excluded, and not by accident, because the idea of nationhood that is not contained within borders, the idea that there is a political community to be recognized in the international system, which is not determined by the principle of permanent population of defined territories, is something that really is part of what was repudiated in the area of Axis era fascism. We can talk about what actually occurred during the interwar period when states asserted rights to unify their sort of kinfolk across borders in other states. With horrifying examples. And so the purpose of the UN order was to establish the sovereign inviolability of states as the basis for peace and as the framework for international cooperation. So this was really at the core. How do you get there in circumstances of ideological pluralism? You have, I give you in the sheet here on the front side, a couple of passages from two documents of significance coming from the United Nations. The Universal Declaration of Human Rights, which in most respects is talking about the inviolabilities of the individual and the right of individuals to the sort of context of a dignified human existence, civil, political, economic, social, and cultural. And nonetheless has this line about the will of the people shall be the basis of the authority of government. And that would seem to follow from the idea of states as manifestations of the self-determination of their territorial populations. However, the thing that's obscured about that is that speaks to modern mass politics rather than to principles of liberal democracy. That indeed Hitler would have embraced the idea that the will of the people was the basis of the authority of government, and so would Stalin. That this was an artifact of modern politics more than they were an artifact of any particular formula for political legitimacy. The association of the will of the people being the basis of the authority of government with a particular set of norms about periodic and genuine elections by universal and equal suffrage held by secret voter equivalent voting procedures is the potentially radical or subversive aspect of Article 21 of the UDHR. And that is the potential introduction of liberal democratic criteria for the gauging of what counts as a government that is a product of the will of the people. However, even from the very beginning, Article 21 was drafted to avoid that issue. The suggestion of speaking to multi-party elections was rejected because of the opposition of the Soviet Union. And over a long period of time, a discourse was developed on the part of one-party regimes that tolerated no organized opposition to basically harmonize their understanding of political legitimacy with international instruments about the right to political participation. And you can see these lovely reports from the Soviet Union and the German Democratic Republic and other such states that speak to all of the ways in which people participate in government in these countries, and therefore how those countries fully satisfy in their own way, by their own criteria, this idea of the will of the people being the basis of the authority of government. So this itself is not as remarkable a statement as it might appear, particularly in the context of an international legal order premised on sovereign equality and therefore non-intervention in the internal affairs of states. So you have this language from the Friendly Relations Declaration. I just want to call it the grudging accommodation declaration rather than friendly relation. You get the sense of people, sitting around holding hands, singing "Kumbaya." That's specifically not what the Friendly Relations Declaration was for. It was really quite the opposite. It was, how do we have a framework of accommodation among people who are not going to agree about fundamental matters? Well, one aspect of this is that every state has an inalienable right to choose its political, economic, social, and cultural system without interference in any form by any other state. And you see a lot of those declarations by the UN General Assembly over time, frequently with language like "on any pretext whatsoever," "for any reason whatsoever," and so forth. And this language is, by the way, derivative of the language of self-determination, that all peoples have a right to choose their political status and freely develop their economic, social, and cultural systems. And so once states have been created through decolonization, of course, the next step is to protect them from neocolonialism. And so the Global South was very instrumental in pushing this particular notion of sovereign equality. And sovereign equality matters, by the way, from the standpoint of weak states. Powerful states don't need to assert sovereignty in any legal sense in the international order. They can take care of themselves. Sovereign equality is really fundamentally about weak states. But of course, weak states can be internally predatory. And so this is a sort of fundamental problem of the international system, that you had an international system that took for granted that states that were governed effectively, the term was effective control through internal processes, where there was a regime and effective control through internal processes, for international legal purposes, it was taken as unproblematic that those governments represented the states for purposes of asserting rights, incurring obligations, conferring immunities, and so forth in the international order. And so that was the basis of the Cold War settlement of these ideas. It also had a hard edge of repudiation of those who overtly failed to observe the principle of self-determination of peoples. The recalcitrant colonialists like the Portuguese, who insisted that Angola was every bit as much part of Portugal as Lisbon, or those people who perpetrated apartheid in Southern Africa. And so you had many aspects of this that actually did give rise to collective action, even across the Cold War divides, against, for example, the apartheid regime in South Africa, and against the proto-state of Rhodesia, which arose from a sort of deviant decolonization, that is to say, colonial settler declaration of independence in order to maintain the system of white domination in what had been the colony of Southern Rhodesia. So the international system did actually take seriously a kind of common denominator of values even during that Cold War era. But of course, you move to the 1990s and you see a very different set of circumstances where the Soviet Union is gone. Revolutionary socialism is in a state of demoralization, if not collapse. The idea of Marxism-Leninism as an orientation toward the idea of legitimacy and the exercise of power is at a low ebb. And so it becomes possible to imagine that there are ways of establishing legitimacy of state order internally, which transcend national boundaries, that transcend the kinds of prior divides that there had been. And so new life is breathed into old propositions about the right to political participation and about the idea of the will of the people being the basis of the authority of government. And so that's really what the emerging right to democratic governance was about in the early 1990s, not only being articulated by scholars, but also by various figures in the international community, particularly centered in the United States and other NATO countries. The democratic entitlement thesis can be boiled down, as I point out in the outline, into three components. That first, the human right to political participation has a determinate content that's grounded in liberal democratic institutional practices. So it's no longer going to be accepted that the one-party regime that tolerates no organized opposition can nonetheless comply with the principle of political participation. Political participation now means something associated with the way that the elections have been run in the Western liberal democratic states. Secondly, that there is a determinate relationship between those participatory processes and the actual exercise of power within states, so that reserves of power by the military or by others that sort of treat political participation essentially as a kind of consultative exercise without real capacity to change the exercise of power in the state, these become invalidated. And then the corollary to all of this is the undermining of the previous understanding of sovereign equality by qualifying that, taking seriously that what's sovereign equal is the set of political communities, not their ruling apparatuses as such. And what's going to be the relationship between the political community and the ruling apparatus? Well, that's going to be determined by these principles of the right to political participation. And so the sovereign rights of states in the UN system, being predicated on principles of human rights and self-determination of peoples, cannot be asserted by non-complying governments against measures to implement democratic rights. That corollary was only gingerly suggested by the advocates of the democratic entitlement. Many were quite cautious. Some were not, like Michael Reisman. Michael Reisman, one of the sort of major figures over many decades in international law from Yale Law School, a sort of foundational figure in what's called the New Haven School of Jurisprudence about international law, that some of you may have learned about. In 1990, in justifying the invasion of Panama, he said that basically the United States, rather than intervening in a sovereign state in ways that were hostile to the principles of international law, actually was redeeming the sovereignty of the Panamanian people. He said, when the people's confirmed wishes are ignored by a local caudillo, strongman, who either takes power himself or assigns it to a subordinate he controls, a jurist rooted in the late 20th century can hardly say that the invasion by outside forces to remove the caudillo and install the elected government is a violation of national sovereignty. Came as a surprise to many of us, but this was the driving idea at the core of all of this. And even the much more cautious advocates of the democratic entitlement nodded to it in certain indirect ways, although there was always a question about how process related to substance in this regard. The notion that you could generalize free and fair elections as the solution to questions of political legitimacy was predicated on a set of assumptions about the ability to, first of all, define what it meant to have democracy, and second, to sort of a certain set of assumptions about how political conflict within states could be accommodated through liberal democratic mechanisms. So I have on the back end of the paper here three distinct roles of free and fair elections. Probably better to talk about them in the reverse of the order that I've given. To talk first of all about democracy, because when people talk about a right to democracy, they often just associate this with a set of procedural norms, especially with respect to the notion of free and fair elections, but also, of course, various kinds of civil and political liberties that underpin the notion of free and fair elections. But it turns out that the set of criteria are assembled based upon some teleological conception of what it is that's sought to be accomplished by this. And so the way I have always put this is that we don't know what democracy is unless we know what it's for. And it turns out we don't agree about what it's for. And so the invocation of democracy in regard to these kinds of procedural norms and mechanisms largely misses the point. And part of the problem here is that people have their own conception of what democracy ought to accomplish. And when the procedural mechanisms are perceived to produce, as I say, either an acute or chronic failure to achieve democratic ends, Democrats will predictably defect from the procedures. So the reason why people could associate so blithely the procedural norms associated with democracy with the actual thing of democracy is because they were satisfied enough in the particular context within which they were with which they were familiar, that these procedures would give rise to the realization of these kinds of ends. But that might turn out not to be the case, and particularly if you have questions about what I've referred to following Ronald Dworkin as the structural and relational conditions of a democratic political community. And the structural conditions have to do with matters about self-determination, have to do with the question of whether the territorial state actually functions as an undivided political community, does not deny self-determination systematically to a discrete part of the community that considers itself a different nation, and also that the governmental decisions systematically reflect what Dworkin calls equal concern and respect, or equal status of members of the community, that political equality is not just, or even primarily, one person, one vote and majority rule. After all, if each person has one vote, you can have a situation of predatory majoritarianism where 51% of the people have 100% of the power and the rest have 0% of the power, and that's not political equality. And so we understand these systems as being more complex than that, but actually having a relationship to a particular set of policies that at least many of us have associated with the essence of democracy, and they include various kinds of egalitarian social policies that at least arguably are necessary to mitigate economic inequality, material insecurity, and social stratification. That these things are actually part of the essence of democracy for many of us and not for others of us. That different people have different ends associated with democracy, and that where we see societies under fundamental stresses, where the stakes of political contestation are sufficiently high, then the sense that one's set of purposes associated with loyalty to democratic procedures are being compromised, that those purposes in fact are being subject to systematic frustration by an entrenched set of procedural norms, that this becomes unacceptable even from the standpoint of people who believe that what they're doing is pursuing democracy. And that relates to some of the other materials in the outline, which I don't have time to go through. But what you see is a situation where if the stakes of politics are high enough, that people will resort to various kinds of measures associated with authoritarianism in order to establish what they understand to be the fundamental requisites of anything that could properly be called a democratic society. And it was always easier for me to understand this from the vantage point of people on what might be called the authoritarian left in an earlier era, in situations where you had, for example, states where there was a kind of radical economic and social inequality such that the superimposition of notionally democratic procedures on those states really failed fundamentally to solve the democratic problem of those states. What many of us did not anticipate was that we could have people from the other side of the political spectrum, particularly concerned about the problematic nature of political community, and especially people who have great fears about immigration. And the way in which immigration can change something fundamental about the political community, and therefore the sort of foundations of social solidarity in the political community, how those people might react. And so we get this notion of the Flight 93 election, to cite Michael Anton from the 2016 campaign. You have people who think that it's actually an existential question whether their opponents win the election. And so there are a whole series of things that come out of this, a whole series of challenges coming primarily from the political right that regard entrenched institutions as being fundamentally part of the problem, is sometimes referred to as the deep state, of course, that the way that you have to uproot entrenched elites is through an entirely different model of politics, and one that emphasizes, in terms of populism, especially right-wing populism, but not exclusively right-wing populism, this relationship, kind of unmediated relationship between the base and the leader as articulating popular will and concentrating the authority that's necessary in order to be able to uproot established institutions and realize the genuine goals of democracy. And that is, there are not a lot of things that unite an Hugo Chavez on the one hand with, say, a Donald Trump on the other. And I've always been resistant to people who've tried to create any kind of moral equivalence, but there is a certain kind of conceptual equivalence with respect to the attitudes towards institutions and what's necessary to achieve what are understood at some level as fundamental ends of legitimate authority. Much more to be said. I always have 2 hours worth of things to say in 35 minutes. So I'll yield at this point, but perhaps there'll be some questions that will focus on things other people are interested in. But thank you very much.
Thank you, Professor Roth. I also forgot to tell our symposium attendees, you'll all notice we have post-it notes. If you have a question for any of our speakers, feel free to write it down and stick it on the sides of your tables. We'll come around and we can ask a brief Q&A if the question is good enough.
That's authoritarianism in practice. Yeah.
I do have one question for you.
Yeah.
In your opinion, is the UN and other international courts becoming less relevant or stronger in this decade based on
what you've noticed and researched.
Well, it's interesting that, of course, there's been over time just institutional development and also much more recourse to the International Court of Justice than there's ever been. And so it's really, quite remarkable just in procedural terms how much more of this you get. In spite of the fact that there is not really, sort of widespread acceptance of jurisdiction over large numbers of issues. And that's why you get these very strange cases before the ICJ that focus on on jurisdictional grounds on very peripheral aspects because the main body of issues can't be taken up by the courts. So you have this paradox that the courts are busier and busier. They're more and more creative litigators trying to find ways of getting issues before courts, but courts are not necessarily vested with the jurisdictional capacity to address what it is that they're being asked to address. That's specifically a problem when you talk about the Genocide Convention as the basis for jurisdiction over matters. And you see a situation like with Bosnia and Serbia, where Serbia effectively seems to win the case because mere crimes against humanity and war crimes are not within the scope of the jurisdiction of the court, but genocide is, and genocide is understood in a very limited way. So courts have limited capacities in that respect. In terms also then of what capacities courts have to see to it that their judgments are complied with, this is as much of a problem as ever. And of course, the solution for the ICJ ultimately is under Article 94.2 of the UN Charter, getting a Security Council resolution. And of course, the Security Council can be stymied by vetoes. And so not clear where we go from there. Yeah.
Thank you, everybody.
Take it. Yep.
All right, before we welcome our next speaker, I just want to again remind you that please, by all means, if you have a question, write it down and stick it on the side of your table.